Good afternoon. Hello, everyone. Thank you for joining us today. My name is Nick Chavez. I'm here with my law partner, Martin Valko. We're with Chavez and Valko, your key to immigration solutions. And well, we're here to discuss the excellent news about DACA, and we're here to take on your questions. It's what we've been waiting for at least since the summer with the huge Supreme Court victory. But really quickly, before we begin with DACA, I just want to make a quick update on TPS. The last couple of days has been nothing but good news immigration-wise. As you may already know, TPS was set to expire early next year for nationals of El Salvador, Honduras, Haiti, Nepal, Nicaragua, am I missing something? Sudan. And based on ongoing litigation, USCIS announced this week that TPS has been extended through October 4th of next year for those countries. So that is definitely excellent news. So on Monday, USCIS announced that it would now be accepting DACA applications from individuals who hadn't applied before. You might remember that a few years ago, the Trump administration closed the door for those who were trying to apply for DACA for the first time. And so there was a lot of litigation, and they were only accepting DACA renewals. But over the summer, the Supreme Court made a huge decision, which left basically the DACA program alive for the time being. But even so, USCIS was not having it. They were refusing to accept initial DACA applications. They were rejecting them until now. Federal court last Friday ordered the agency to treat DACA as it existed before they tried to shut it down in 2017. So this means that USCIS will accept first-time applications, advanced parole applications, and basically operate the way they did back then in 2012 when DACA was created under those original guidelines. And so that's where we're at now. USCIS, by the way, I don't think they have updated their DACA filing webpage, but they did say that they were returning to their original standards. So they have to comply with the order. And this also includes issuing those 2-year work cards instead of the 1 year as they tried to do in the summer. So that's where we're at now. Martin, this is we're getting questions from people who are wondering, what to do with DACA. We have a question here now from somebody who's listening to us right now, and they're asking, as a first-time applicant, do you recommend getting everyone done through a lawyer? That's a good question. Or send the application myself, and if she does it herself, would it take longer? What do you think, Martin?
Well, again, welcome everybody, and we're just so pleased with this development. It seems like USCIS have been taking their sweet time as they have in the past, and so now this is a gift for many of you under the Christmas tree, and so it's fantastic that it's finally back on. In terms of getting an attorney to assist you in the process, DACA applications are, they have certain requirements laid out that the person has to meet, and as long as they meet it, they should be able to apply. We have participated in various workshops where we assisted applicants, young applicants, first-time applicants, and they were able to do it themselves. It's not a rocket science, but at the same time, that if you are working with an experienced, licensed attorney, obviously attorneys have to be licensed, then you should feel comfortable and rely on their experience and on their recommendations and advice. We are licensed by individual states. We're professionally responsible for our work. So if anything is not done properly, applicants have a recourse against lawyers. They can go to the state bar and they can complain, and so you cannot do that, if you do it on your own. Obviously, hopefully you don't make a mistake. If sometimes people go and use various notaries, notarios, and also they are not responsible for their work. In fact, a lot of times they disappear. So, and there are BIA accredited representatives. There's so many other people, some people that can assist you in this process. So long story short, can you do it on your own? Yes, when you follow the instructions, and if there are no other issues, there are a lot of times when we consult with people, we find that there are some grounds of inadmissibilities that potentially that could lead to a potential deportation. People may have been convicted of certain crimes, and they think, well, it's not a big deal, I can go ahead and submit it, and then they can find themselves in removal proceedings. So, long story short, can you do it on your own? Sure. Will you be served if you go with an attorney, if you find the right attorney, if the legal fees that you pay for are comfortable and you are okay with it, then I'd say go with an attorney who will be responsible for the process.
Yeah, especially if your case is complicated or involves arrest records. One of the things that immigration has in place is this policy that if you file an application and if they believe that you not only are ineligible for the benefit, but you're also deportable, this is something they can do if your application is denied, particularly if it's denied for having a criminal record. And the other thing, as attorneys, I always like to say that, we're not magicians. We're not somebody who's going to wave a wand and make things faster, but we do minimize delay. I mean, we're able to, we do this, Martin and I do this on a daily basis. We identify what the issues are and we're able to maneuver around. So in that respect, it is beneficial, but it's not necessary. It depends on what your case is. Very good question. Thank you for that question. We have another person who wrote in and is asking, let's see if we can see this. If I went out of the United States after 2007, would that affect me? I don't know, Mar, do you want to take that one on, or?
Well, one of the one of the major requirements for applying for DACA is proving continuous physical presence from June 15, 2007 onwards until now, until submitting the date of the submission. And you generally have to show that you have been here by submitting evidence to show physical presence. I believe we've had cases in the past where people did leave the U.S. And as long as they were not absent for what's called a continuous, a brief, innocent, or casual period outside of the U.S., was generally is about under 90 days. Then they were fine, and the DACA application was approved. Again, those are the type of cases that I would recommend consulting with an attorney so they can look at your overall fact pattern to determine whether or not you are approvable or whether or not the application will just be denied. So I believe we've had many clients that had traveled out after 2007, but each of those cases fact pattern differed, and so for that reason, I would recommend Yuvia to setting up an appointment, whether it's with us or any other experienced immigration attorney.
Yeah. So it's from 2007 to 2012, as Martin mentioned. They're going to go ahead and excuse what you call brief, casual, and innocent travel outside. But after a certain time frame, well, after 2012, when I believe it's in June, of 2012, after a certain date, if you leave the country, this could interrupt your continuous residence. It could affect you unless you had some kind of travel permit, like an advanced parole. And we also have some individuals who unfortunately had to leave by order of a deportation order or some sort of, they were forced to leave, and that would also interrupt your continuous residence.
Yeah.
So Yuvia, thank you for your question. Moving on, we have another question, and this is from Lizette Anaya. I came to the United States in 2010, and I have proof. Am I eligible? So one of the requirements that we mentioned earlier for DACA, you have to show that you've been in the United States from June 15, 2007 and on. Unfortunately, they haven't changed that requirement. And it's unknown right now whether or not they're going to change that requirement to show that you've been in the United States since June 15th, 2007 and on. We hope, and anything's possible with the new administration. DACA right now it's being litigated in the courts, and we hope that the administration, can change up things. There's a lot of people who came after that date that unfortunately weren't able to apply for benefits. People who are going to school, people who are just basically living here and contributing to our society. So we hope that changes. So yeah, we also have a lot of questions, from people who meet the requirements for DACA, but they're missing one or two. And one thing that's really common that we've seen is that we'll have a client come in and they say, look, I've been here in the United States, before 2007, I was here. I have no problems with the police, but the only thing is I didn't finish high school. And that's a very common question that we get, right, Martin? So what are some of the options there? And that's actually a question that we got over the week from a client who was thinking about taking a GED program. What do you think there, Martin?
Well, there's a lot of people out there, right, that they started high school and they did not finish. So obviously, if you're in school, you're over the age of 15, you qualify if you meet the other requirements. If you hadn't graduated, if you dropped out, many reasons why people don't finish, they can enroll. Obviously, can go back to school. You can enroll in a accredited GED program, and typically just being enrolled without actually having had graduated and obtaining the GED certificate was sufficient to submit the application. So make sure that you don't go initially. There were a lot of GED programs that just kind of popped up everywhere, and not all of them were accepted, and it caused a lot of denials. So you want to research it well. Perhaps go to a local community college that offers the GED programs and do it. Obviously, you're going to benefit yourself by having graduated, by having to obtain this certificate, and also qualifying for DACA. So that's typically what most of our clients do.
Yeah, it's going to be very interesting now with COVID, because a lot of these courses, GED courses, are now being offered online, and that's going to be one of the questions, right? That does enrollment on an online course, does that qualify for this currently in school requirement for DACA? And as you mentioned, Martin, as long as they meet those requirements, that it's an educational program. It's whether it's funded by the government. There's some community colleges that offer this, and I would argue that it would qualify. Or if it's not funded by the government, or it's not a community college course, you have to show and this is a fancy term they use, but demonstrative effectiveness. Basically, they're trying to see if this is just a company or organization that just popped up and really has nothing to do with education, or is it established? Do they have a track record? And that's has been one of the challenges when DACA first came out, is that there are a lot of these organizations and individuals that say, hey, I can offer this course, and they weren't accredited. And so they were denied on that basis. One of the other questions that we've been receiving is regarding the travel, the advanced parole. That's the word that's used for travel internationally. And so you know, with these changes that we see right now, it's very favorable. And as I mentioned earlier, advanced parole, it will be allowed. It will be allowed for those who currently have DACA, and they're going to go by the old standards. And the old standards with respect to advanced parole, you have to show that it's for a humanitarian purpose. This could be a medical. This could be for medical treatment, or you're attending a funeral for a relative, or visiting a sick relative, or it could be also be educational. There's programs that have these learn abroad programs, and that is a possible way that you could apply for advanced parole, or employment. We have had clients before who they're working for a company, and this company wants them to go to this important business conference, and as long as they make this application, as long as they have DACA and they make the application, which is on form I-131, they have a shot at applying and obtaining the travel permit. But it's not automatic, and this is another comment we receive from our clients is, well, some of them think it's a sure thing. I don't know the statistics, but I know that they had denied more requests than granted them, and I suspect it's going to continue that way. So you have to have a really good excuse for traveling abroad. The other question that we have received, and it's actually a very common question, it's a very common occurrence, is what types of offenses can disqualify you for DACA? And as we mentioned earlier, there's certain requirements for DACA. You have the educational requirements, you have the age requirements, but you also have to be on your best behavior to apply for DACA. Not everyone's going to get it. And there are certain offenses that can automatically disqualify you. You have if you have been convicted of of a felony, and a felony is a criminal offense, federal or state law that is punishable by jail for over a year. So if you were sentenced, if you were convicted of a felony and you were sentenced longer than a year, then you're not eligible for DACA. The other is the other thing you have to watch out is these significant misdemeanors. And what is a significant misdemeanor? And immigration, they list it out. If you've been convicted of a significant misdemeanor, this means this includes domestic violence offenses, those assault offenses that occur in the home. If you're convicted, you may not be qualified for DACA. Sexual abuse, unlawful possession or use of a firearm, that could also kick you out. Drug distribution, if you're convicted of drug dealing or trafficking, that could also disqualify you. And one of the more common offenses that we see is DWI or DUI. Those offenses can disqualify you automatically for DACA. And then they could also disqualify you if you have 3 or more non-significant misdemeanors. Basically, any misdemeanor that wasn't listed, other than a traffic offense. If you have 3 or more, that could disqualify you. Now, they list out these criminal offenses, but immigration could always, even though you may not have been convicted of a felony or a significant misdemeanor, if there are signs that you haven't been complying with the law, then they could deny it based on what they refer to as their discretion. Discretion means like, even though you meet the requirements, I still don't think you deserve it. And we've seen this play out when people have multiple traffic tickets and they just disregard them. They don't pay them. And so USCIS, their take on it is like, why should we give you this if you're not even paying your tickets? And in that particular case, it was like something like 6 or 7 tickets. So yeah, pay your tickets, very important. But if you feel, if you ever have been convicted of an offense, or if you have been arrested, or you're currently in proceedings, very important to speak to a lawyer to see if there's a way that we can avoid a conviction, so that way we can preserve your eligibility for DACA.
Okay, Nick, have you ever had a consultation where an applicant tells you that he doesn't understand why he cannot apply for DACA if he was convicted of DUI, but he has a friend who had a simple possession of marijuana and his DACA was approved?
Yeah, you know what? It's and that's the way that the rules are written now. It's the irony. Yes, a DWI for DACA will disqualify you. A drug possession for marijuana won't. And if you were trying to apply for your green card, it would be flipped.
Mm-hmm.
A drug possession offense could potentially disqualify you from getting a green card, and a DUI or DWI doesn't necessarily. So yeah, that's one of those quirky things. And sometimes we see clients mix, they sometimes they confuse the processes, and they think that they can do it. We have, I believe we have some comments here. Let me see, we can get to them.
Just wanted to add to the DUI, what I would like for everybody to understand is that whenever something does happen, and I understand things do happen, make sure you reach out to a good criminal defense attorney who either has knowledge in immigration law, or he works with immigration law firms such as ours, where we could provide the right advice, where we could assist the criminal defense attorney in structuring the plea agreement in a way that the original DWI charge will not turn into a DWI conviction. We've had cases where the district attorney accepted plea of it skips me, basically like stopping the flow of traffic. I forget the term, obstruction of highway or obstruction of a passageway. And it starts with a DWI conviction or a charge, but it ends with a obstruction of a passageway conviction or a plea agreement, and bam, then the person does qualify for DACA. Otherwise, they don't. So a lot of times they go to a criminal defense attorney and they'll tell them, look, you will not do any time. Go ahead and just plead to DWI, and they don't really consider their immigration standing or the lack of status or potential problems in the future. And so it is very important, especially in the very beginning, is to reach out to an immigration attorney, especially if you're not hearing from your criminal defense attorney to give you any advice or sending you to an immigration attorney. So just make sure you do that. Yeah,
that's very, very good points. So moving on, we have some questions, and this one comes from Darlene. Darlene asks, thanks for having this Facebook Live. Well, thank you, Darlene, for posing your question and for following us. Any advice or recommendation on advanced parole? Advanced parole, again, is that international travel permit. Is it a good time to apply? The risks, what are the risks, right? Well, the good thing is that the risks, if you're applying for advanced parole, if you are thinking about what are the risks for applying, if you already have DACA, there really isn't any risks. They just deny it and that's it. But if they give, but for certain people who are applying for advanced parole, I don't know if you remember it, and again, we have to consult with the old guidelines. So it's been a while. We have to brush up some of the policies that they had. But if a person who immigration, if you recall, warned us that if you apply for advanced parole, if you have a deportation order, you have to get that result, or you should get that resolved, because upon entry, you could be you could have some problems there with the CBP officer upon entry if you don't resolve your deportation order before traveling. But as far as the risks, if you're applying for the first time, there really isn't if you already have DACA, which is you have to have DACA to apply for advanced parole. You just have to show that it's for a humanitarian purpose. You have to show that these are extraordinary circumstances that you need it. And it doesn't have to be based on one of the things that the examples they put out. We've had clients who, even though this was not listed in their FAQs on their website, they were allowed to travel based on they had a religious, it was for a religious purpose. They were part of a worship team at church, and they were wanting to go to Mexico. This person had DACA, wanted to go as well. We got letters from the pastor, from church leaders, describing what the reason was for their, and she was able to get her advanced parole.
If I could add to that, there was one of the questions about, well, that was it, right? It was from Darling for about the ill grandmother. So your typical advisory initially talked about immediate family members. So that would mean your parents, your siblings, but we were able to, and many others were able to apply and get it issued, get the advanced parole issued for traveling to see an ill grandparent, for example, or there's maybe a medical emergency or somebody had passed. They were issuing those, but whenever there was an opportunity to apply for something similar for the same emergency advanced parole locally at the field office, so USCIS has offices in various jurisdictions in various cities, and they would deny those. And so you have to be careful. Obviously, we haven't heard whether USCIS will start issuing those emergency advanced paroles locally for DACAs, but that was the differentiation. They would, for example, they would approve it for parents if the parents were the reason locally, but on the national level at the service centers, they also considered grandparents. And so, again, Darling, that was one of the earlier questions. As long as it's well documented, you have medical records, you may have the diagnosis or the doctor's prognosis, and it's well laid out, you should be able to apply and obtain it.
Yeah, good point there, Martin. Moving on, we have a question from Diana Rosas. Diana, thank you for your question. She asks, I have not renewed DACA for 3 years. Can I renew it again? Well, correct me if I'm wrong, Martin. If you had DACA and it expired and you want to renew it, but it's been a year or longer since that, you can apply for DACA, but it would be treated as an initial application.
Exactly. So you basically, because you ask, can I renew your DACA? So it wouldn't be a renewal, it would be an initial application. It's been more than 12 months, so you would have to get all the previous evidence supporting documentation that you submitted to USCIS plus up to the point of application. So basically for the last 8 years, you would have to have the supporting documentation. So yes, you can. It will be treated as an initial application.
Great. We have a question regarding some of the evidence that you can use for DACA. Also, can I use the letter that they gave me at the hospital when I gave birth to my son as proof? It has my name on it. And this is in reference to that question regarding what kind of proof can you show to establish continuous residence, which is a requirement for DACA since 2007 and on. And my answer is yes, you could use any type of document that is verifiable, that contains your name and a date, you can use that, and hospital records are great because they're verifiable. We have another question here from Carla Romero. And can someone who was previously denied reapply, denied to insufficient evidence? And that's a very common situation, right, Martin? We get some of those cases.
Yes, we do, and we always evaluate the case to see what was the issue previously and why was it denied. A lot of times when we work with clients, when we assess it, we let them know whether we think the case is approvable, whether there might be a pushback, whether there might be a request for additional evidence, and let the client decide whether they still want to submit the application. And so definitely, as Nick mentioned earlier, there's really nothing wrong about that, and there's you can reapply it as many times as you want. Thank you, Carla.
Okay, so and we have another question. This is from Montalvo, Jocelyn, and she is this a full green light? Should we wait since the December 22nd? They can still DACA still change it and try to eliminate it again. And there's a lot of litigation happening right now with respect to the litigation and that aspect. As of now, USCIS has given the green light. Can that be taken away? Well, the funny thing about litigation, and if you've been following DACA for the last 2-3 years, you should know this, that it's a roller coaster. It goes up and down because of litigation. So if there is an order, the other side can appeal it and get what's called an injunction or an emergency injunction or emergency stay, I should say, against that order, which then would make it where you couldn't file it. Can that happen in the future? Yeah, this is litigation. This is what's happening. Is it likely? I really can't say, but I think it's advisable. USCIS given you the green light for now. If you meet the requirements, you should do it. But that also depends on what your history is like, because there are certain people that I would not recommend they apply based on their background, or they might not have enough evidence to show, and they might have a weak case. And so those are things that I think are better left for a discussion with your attorney.
Yeah.
All right. And thank you. Gracias, Yuvi, por su comentario. Aquí estamos para servirles. Y gracias. Por favor, comparte nuestra información con sus amigos y sus familiares. Aquí estamos para servirles. Gracias. Igualmente, Carla, thank you, Carla, for that nice comment. Darlene Campos has asked us a question: is an elderly ill grandmother a humanitarian reason for advanced parole? Yeah, go ahead.
Yeah, no, we already addressed that. It was Darlene's second question, or the earlier question, and yes, again, it just depends. But I just go back to our previous cases, and we've had ill, sick grandparents, and the advanced paroles were approved. In fact, for example, and Nick mentioned the variation that it necessarily doesn't have to fit their FAQs, but we've had somebody who was like a mother, somebody who raised the child, the applicant, the person who was applying, and were able to show the connection, and that person was having some health issues, and the advanced parole was approved as well. So again, it's case by case. It's very discretionary. But if you believe that you meet those requirements, if it's well prepared, I'd say go ahead and take a shot at it.
And I don't know if we got around to this. We might have already addressed this question. If there is a gap, no evidence of being present in 2014, proof prior to 2014 and 2014 only. I would say that one of the more common reasons why USCIS has denied DACA applications is because of these gaps. If they feel like the evidence that you provided doesn't sufficiently establish that you've been here for one of those years. I would say that do your best that you can. You have to think outside the box. You have to look at, I don't know, I tell some of my younger clients, look at your Xbox subscription. I don't know if that sounds pretty old. Look at other things. Maybe indirect evidence. Maybe you were at Six Flags, and we know that you were Six Flags because you have a picture and it says Fright Fest 2004 or something, 2014. So those are the type of things you have to think outside the box. A letter just by itself, unfortunately, is not going to cut it. We have clients that don't have any evidence for a particular year, and they ask us, well, can so-and-so write us a letter? Unfortunately, usually it's not enough. It has to be supplementary. So if you find any type of evidence floating around in that year, 2014, anything, then you can use an affidavit to maybe help your case. And if you're going to use an affidavit, a letter from someone that can verify that you were here, I would also recommend that that person who's writing that letter be specific. Write down exactly how they know you. How is it that they know that you were here in 2014? A copy of their driver's license if possible. And I would even add that that person should also show that they were also here in 2014. We see that sometimes USCIS will ask for that type of evidence from the person who's writing the affidavit. Okay, and so we have a question here from Juan Pedraza. Well, Juan, we appreciate your interest. As far as the filing fee for USCIS, it's currently $495 with the biometrics. I'm really bad at math, right? Is that correct?
Yeah, 410 plus 85. Yeah.
Will it? I think that's going to stay. I don't know if there's going to be any changes. As far as our office, we recommend highly that you set up a consultation because it just depends on what your situation is like. There are some straightforward types of cases, and there's cases where we're going to have to advocate more for our client, especially those who may have been, maybe missing a year or have been convicted of an offense, and we can show them that they should not be disqualified. So it just depends. I would recommend that you give us a call, or you could book online, and we'll be happy to discuss your case with you. We have a message here from Chio Nieto, and Chio Nieto writes, I tried to renew my DACA last year. It's been expired for almost 5 years. Unfortunately, I couldn't gather all my paperwork on time, and they sent me a letter that my time limit expired and that I can no longer reapply. Can I try to reapply now? I think you can, Chio. There's, even though you may have applied and it's expired, this gives you a new opportunity. You can file the new, but you would have to show, you would have to file it as if you were filing a new application, it appears. So you would have to submit evidence that you've been living here in the United States continuously, at least from 2007. So that's almost 13 years. Okay, here is another question. It's kind of interesting because we hear a lot about this past year. We heard a lot about this thing called public charge, the public charge rule, or the welfare rule, whatever you call it, which USCIS, or the administration, I should say, really tried to scare immigrants into applying for certain benefits by saying, look, if you apply for certain welfare or public assistance, you may not qualify. And so that's been in the public conscience. So people are thinking about that. And here, if you owe a fee from an emergency center, I wouldn't think that disqualify. In fact, they don't ask any of those questions. As far as I'm concerned, they don't ask you if you owe any money. And as far as that, I mean, I would obviously say that you should try to resolve that. But that does not necessarily disqualify you. I don't think it's on the form. Darling, well, we're here to help. We're here to help. If you have any questions, we could definitely try to help you. And if you want to discuss your case with us on a personal level, we're here to help. We have a question here from Norma Salazar. Norma Salazar, your question has me like floating underwater here, but we'll try it. If you already have a petition for an alien relative spouse in place, which is the I-130 petition, and you already have an approved waiver, and the beneficiary is also a DACA recipient, so this person now has DACA, would you advise that an attempt to get advanced parole is made to get that legal entry for adjustment of status into the U.S.? That's a good question. What do you think, Martin?
It's a fantastic fact pattern. You have the petition, which is a step one approved. You have the waiver, which I presume is the provisional waiver, which is a second major step to get done. So that the third step would be waiting for the interview notice to come through the National Visa Center once that third process is finished at the National Visa Center, and then travel to the applicant's home country and go to the U.S. consulate to have an appointment for the immigrant visa. So if you are, if you haven't started the third step, that could be another 10 to 12 months, or maybe more, depending on the country. There's still some uncertainty whether or not the person would come back after the interview, or if there may be additional reason for a ground of admissibility, and hence requesting another waiver. But given the fact that you have a petition approved, getting advanced parole would be what I would recommend. It's just a perfect scenario. So if you can get the advanced parole, get it approved, travel out and be out for a couple of days, or take a vacation. Maybe if you're going to a country like Mexico, go down to Cabo or one of the beaches, and then come back and then apply for adjustment of status. So you would be paroled back in, and presuming that everything else checks out, then filing the adjustment of status with the other supporting documentation and other forms would be the way to go, Norma. So either way, it's great. I think advanced parole with adjustment would be much faster to have the person here, and just wait for the processing, and then the interview, and then the green card. Otherwise, you got another 10 to 12 months leaving outside, spending, depending on the country, maybe 5 to 7 days or so, and then coming back. That may not be the way to go. So I would recommend, if that's what it is just getting the advanced parole and coming back and filing for adjustment.
Yeah. We have some more comments here. Yes, Montalvo, yeah, library card records, definitely they do show continuous residence. Same thing with tax returns. The question here is, while in the process for DACA, and this relates to the previous question, can I still get benefits from a gold card? Well, I want to know, what kind of gold card are we talking about? It seems like, but she means green card. It depends. It's the last question. It's certainly an advantage to apply for DACA, and then if there is a way to apply for residence, either through a family relative or another basis, is also seek DACA, so that way you could travel and then come back in. So what I mean by that is that generally when a person wants to apply for a green card here in the United States, that process is called adjustment of status. And one of the major requirements for adjustment of status to apply for your green card here is to show that you last entered with some sort of permission, a visa or some other valid document, that you entered, you were inspected, that the officer let you in. Now, there are some people who entered without inspection, and there are problems in applying for a green card here. Now, there are some exceptions. Even though that person may have entered without inspection, they may still qualify under certain exceptions. But if they don't, and they want to immigrate based on a petition filed by a spouse, for example, a U.S. citizen spouse. The road to get your green card is outside. You have to go outside and apply for your immigrant visa. That's what they refer to it at the consulate, U.S. consulate. And that means that you have to go through certain steps. You file that petition, as we mentioned previously, this petition, which forms the basis. And then the second step is a waiver if you lived here, if you were living here without any status for a period of time. And then the last step is to apply for your visa. Well, if you go outside, you run the risk that the officer might find something that would delay your entry or maybe even deny your entry. That's even worse. Or if something happens with your file, it's lost or they need something else. And you're waiting outside. So in those situations, it's advisable if you have a shot at applying for DACA, or you could apply for DACA. That would give you this temporary status, work permit. And once you have DACA, then you can maybe perhaps apply for advanced parole. With advanced parole, then you can leave the country and then come back in, and that satisfies that requirement that we talked earlier about you having to show that you entered with some permit. So if your last entry was with some permit here in an advanced parole document, you might be eligible now to apply for a green card here. So it's just a strategy. Again, I think that you should discuss this with your lawyer if you are thinking about doing that. Okay, let's see. We might have some more questions here, and we have a question here from Adelina Reyes. Adeline Reyes, my husband is a U.S. citizen, and we want to know what he can do so he can do my petition. I have lived here for 30 years since I was 3 years old, but in 2010 I was charged with third-degree felony with tampering with government documents and was given probation. Deferred probation, and I served it for 3 years. I just want to know what's our best option. Yeah, you want to take that on, Martin?
Well, I mean, there's a lot to unpack here, and it's a lot of personal information, Adeline. Our recommendation would be to set up a consultation again with us or somebody else that we can look into the criminal background, the documents, the charging documents, the disposition, to see if there's any possible way of moving forward. What are the challenges we're facing, and if we're facing them, are there any waivers that are available? A lot of times in our analysis or overview of something like this, we want to identify whether or not you were properly advised by the criminal defense attorney, if you had one, or public defender, or if the criminal judge had properly admonished you. That means that, did they warn you that if you enter into a plea or you had this deferred adjudication, what effect would that have? What effect would that have on your future immigration status or immigration process? So that's the step number one that we do, is we get those documents, we analyze them, and then provide you with a plan, with a roadmap. At the very least, have a plan in case something were to happen, in case a person gets detained. We are able to immediately start working on the case, as opposed to reacting and try to do that work at that point. So, you have the numbers on the screen. You could call us or call anybody else you feel comfortable with, but that's what we would do as a first step.
Yeah. And we got a clarifying question, and from that gold card question, and sorry,
that's what I thought. It may have been some kind of a benefits.
Yeah, and well, I have clients call it gold card. It is sort of like the prize here. No, it won't. Those types of if you're getting medicine or anything that's related to health, they don't even ask those questions on your DACA, and they should not disqualify you. I would not be scared or worried about that. If you qualify for DACA, by all means, you should I encourage you to look at that, look at the requirements, talk to an attorney, and take advantage of the opportunities that are offered. Okay, well then, let's see here. We have a question that was submitted earlier, and it was kind of some of a general question. You know, and this is what a lot of people are wondering right now. Is DACA here to stay? I mean, are they going to pass any laws to protect dreamers? And this is something that Martin and I have been monitoring almost on a daily basis. The ups and downs of DACA and potential dreamer legislation. And in DACA, you know, as a reminder, DACA is not a permanent solution. It's a temporary solution. It's something that was created by an administration. It's an agency benefit, if you will. It's not a law. And that's the problem. That's why we are seeing a lot of litigation. And so the solution would come with legislation, with Congress passing permanent protections for dreamers. This is something that's important, and this is something that we've been monitoring. Very, very possible. You know, there's going to be politics. We're expecting that. But until we see permanent protections, you're going to see this ongoing litigation. Earlier with that comment, that audience member who was worried about should I submit it prior to the case being appealed or not. We could avoid all that if there's a permanent solution, and we've seen signs of that in the last few years. Well, dating back, you know, maybe even beyond 5 or 6, 7 years, there was legislation, you know, prior administration, even the Obama administration, we wish that they could have acted on it, but there has been proposals, and they look a lot like a DACA. You have to show that you've been here for a certain period of time, that you went to school, that you did not get into any problems with the police. Those are basic requirements. And if we see any new laws, I think that we might see a lot of people are still going to get cut out from the original DACA, or they'll meet the age requirements, which is 15. But you might see something more expansive that would include people who even though they showed up after 2007. We had the audience member who asked about coming in 2010 and being disqualified. Well, maybe you know, with dreamer legislation that would cure that. It would be expansive, and we've certainly seen signs based on some of the languages in the proposal. Well, we're about to run out of time, but we have this really neat application. And Martin, I don't know if you want to talk a little bit about that. It's an app that Martin and I developed, and it's we were purely thinking of you all in mind when we developed it.
Yeah, it's something that came to our minds during the enforcement of this current administration, and it's all about better serving our clients, better serving people that really keep us in business, and we want to make sure that they don't feel any consternation, they don't feel that much fear as they were fearing. And so we decided to build this app to connect our clients, to connect even our non-clients with us or other lawyers that may be providing service on this app. But basically, it is an incredible tool to keep you connected with your lawyer in terms of emergencies, in times of emergency. So being pulled over by police, being visited by ICE at home, or any other emergency you may have, when you activate the red button in the middle of the app, your emergency contacts are notified through a text message and an email. Your lawyer gets the same thing, gets the text message, and then the beautiful thing is that the lawyer can then see your location through GPS, through the maps, and be able to know, well, where are you? Which jurisdiction of the police department are you, or ICE department? The app then starts recording the audio and uploads it to the cloud. So the attorney, when they get the alert, can go to the audio and listen to see what is really happening. So it's just a fantastic tool where we as lawyers have your back 24/7. So we actually, as a law firm, have it staffed where we monitor it, and often at 2 o'clock in the morning, it's our team, and I'm Nick, and I are also the first responders that react and call, and clients are just beyond themselves knowing that we're calling and we're kind of watching over them. And then secondly, there are a lot of questions that people want to have answered, and it serves as an educational app where we send curated news about updates in immigration law. So when you have questions about immigration reform or anything else, the minute it hits the wires and we go through it and we assess it, we'll push it out to all of the users so they know that that's the information they can trust. Plus, it has a library of your rights. Know your rights. Know what to do when you are detained or stopped, or what to say, what not to say. It's all there. You have questions about public charge, questions about coronavirus and processing of your case. You go there, and it's in English and Spanish. If you're tired of reading at the end of the day, you can listen to it. It's also recorded. There's an audio clips for each of those entries. So it's just a fantastic tool. For those that are not our clients, you can simply text the word Guardian. It's on top of your monitor of your screen. Guardian to the number 47177. Again, text the word Guardian to 47177, and you'll receive a registration link. Once you register, you'll register with us because we're the providing law firm for this particular code. And then you can go to the App Store or Play Store, download it, and voila, you have it. You have it on your phone, and you can go in and you can add your emergency contacts. You can invite friends or family through cell phone numbers or emails. When you work with us, you'll have access to your case. You'll be able to upload documents. You'll be able to set up consultations with us. So if you would like to receive a free consultation, you can download the app and go to the menu in the upper left corner, and you can schedule a consultation on your app right now. And we'll be happy to see you this week, next week, whatever time works for you. So
yeah, definitely. It really is like the Batman signal. Mar and I are, we're busy at home, and I'm in the kitchen, and we get that alert. And Martin's on it. I can tell you that. Well, thank you all for joining us. I know you're gonna have a bunch of questions about DACA or even about immigration in general. You may have your own case that you are working through. Give us a call or let us know, and we're here to serve you. We're here to give you useful information. We hope we could be of use. And check out the app. In the meantime, just you can check us out. We have a website, and you can check our videos out. We do this on a regular basis. Until then, we'll see you guys later.
Take care. Bye-bye.